It's a monumental change, and hardly anyone knows about it.
Your private doctor can make a serious medical mistake, take off the wrong leg, operate on the wrong side of your brain, and you can never sue him in a jury trial. The I-Team's Hagit Lamore joins us with this remarkable new turn of law no news outlet has reported until now. Hagit?
The Ohio Supreme Court made a decision that sent shockwaves to the few who've heard, yet impacts all of us. In a huge departure from any other state, the court gave many doctors and hospitals immunity from malpractice claims, no matter how clear-cut. It's called the Theobald ruling, and its namesake cringes at the precedent he set for all of us. There was a day Keith Theobald could take it all for granted.
This is Keith.
Horsing around with friends, trick-or-treating with the kids, fit, healthy, in his prime. That day is gone.
There's a plate of crackers on your left.
It's not the accident that left him needing 24/7 care. He was driving his pickup in the far left lane of I-275 near Montgomery Road when a car clipped him, the truck tumbling across the highway into a field, crashing in a tree. Rescue workers found him paralyzed from his chest down.
I can remember preoperatively we talked about, you can still do basketball with Jake and watch TV and share things with the kids. And, we'll get a van and we'll adapt it.
I could, do about anything. I mean, the wheelchair doesn't hold you back. It's just your vision.
The vision. Theobald could see and use his arms after the accident. He was alert and ready the next day when doctors at university hospitals suggested surgery might improve his back injury. Instead,
I would have never expected to wake up totally blind and never be able to see again.
The Theobalds say a series of mistakes led to oxygen deprivation and even worse injuries than the accident had caused.
I sometimes still can't wrap my head around it.
Wheel up to the sink up here.
Still paralyzed, but now also trapped in darkness, Theobald will need round-the-clock care the rest of his life. He sued the doctors who did the surgery, only to get this devastating shock.
They get total immunity because, there's a student in the room with them. I'd never heard of such a thing.
I think absolutely shameful in the United States to sit by and let this happen.
Attorney John Metz says what's happened as a result of the Theobald case has changed the course of doctor-patient relationships in Ohio. Boils down to this: doctors who sign with a state university like UC to let medical students learn from them, even just to watch, now are considered state employees. They get immunity if anything goes wrong on the job in their private practice.
It's not fair if you go to a private doctor and you have nothing to do with a public institution, how somehow you can have given away your constitutional rights.
The state didn't come in and take care of him. The university didn't come in and take care of him. This doctor took care of him. We're suing the doctor.
No, they're not. After a decade twisting all the way to the Ohio Supreme Court,
Keith Theobald versus the University of Cincinnati.
The justices told them the doctors were teaching per their state UC contracts, not liable for any mistakes.
This was a radical departure from where we had been.
Ohio Supreme Court Justice Paul Pfeiffer says his fellow judges changed the law intended for public state workers.
Privately engaged doctors who have a private practice suddenly can hide under the umbrella of the university.
Pfeiffer disagreed with the other 6 who wouldn't agree to interviews. Neither would UC, but they argue patients still can sue in the Court of Claims, where all suits against the state go. No jury allowed. Top award is $250,000, and the taxpayers, not doctors' insurers, pay it.
The taxpayers. So we take away their rights and we make them pay for it.
Representative Mark Oakey chairs the House Civil and Commercial Law Committee.
But I can see how this Theobald decision could be abused. It could be utilized to game the system.
Already, the I-Team obtained this letter from the University of Toledo to its area doctors. This recent change to the law has extended the definition of a state employee for purposes of malpractice liability. Once your insurer understands the benefits of immunity, they will most likely be very supportive.
I think it's shameful, whether it's a university or whether it's a doctor's insurance company, when they try to bend around the rules to deny an opportunity for a just result.
The impact will hit not only patients and taxpayers, but Oki says our healthcare system is at stake.
What are we teaching medical students? Are we teaching them how to avoid liability for medical mistakes? Or are we teaching, or should we be teaching them good medical practice? I think that's where we're putting the public at risk, because I don't see this as encouraging good medical practice. You know, that should be the focus of an educator and a student.
Bang my knuckles, sometimes I have to do that, going through doorways.
Of course, Keith Theobald never knew to ask if a student would be watching his operation. But if you think doctors from now on will have to tell you, you'd be wrong. The Supreme Court ruled the law doesn't demand disclosure. Your tax-paid Attorney General's office, arguing for UC and the doctors, won that round too.
I'm asking you as a lawyer and as a matter of fairness and a matter of notice to people, don't you think that ought to be required?
As a matter of fairness, Your Honor, I don't think so.
Practice of law is supposed to be about achieving justice and fairness. We pride ourselves on trying to have something that's reasonably predictable for people. For this poor guy, it couldn't be more unpredictable.
2, 3.
Keith Theobald hasn't lost hope for a medical miracle. His children, only 5 and 8 years old at the time of the accident, have grown.
Even though I can't see them, you know, I still want to keep pictures.
But in the end, he never did get a chance at even the Court of Claims the Supreme Court said he should access. That's because the same state attorneys who argued that's the court where the Theobalds belonged now argued it was too late to sue the state. The statute of limitations had passed. No recovery, not even $250,000 for Keith Theobald's lifetime injuries.
Talk about David and Goliath. In this case, Goliath won.
And Goliath, you're saying, won not only against the Theobalds,
but everybody else, all the other Davids.
The ruling applies at any hospital, clinic, or doctor's office if your doctor has a deal with a state medical school. Think of that the next time your doctor asks if you mind if a student watches while he examines you. Regardless, you will pay. Your taxes fund not just settlements from the state, but the Attorney General who represents the doctors and universities in lengthy court cases. The only way to change this back would be a law from the legislature to undo the Supreme Court decision.